My name is Chu Machinye, and I am delighted to welcome you to this insightful episode of Your Family Lawyer, your go-to weekly podcast for family issues which may confound you or that you may require clarity for. Our job here is to lighten your burden and show you the pathways to justice where there may seem to be none. Before we dive in, let me remind you to please hit that subscribe button so that you don't have to miss another episode. If you care about your family and about protecting your family's future and avoiding legal challenges after you're gone, this is the place to be at this moment. Now call us or send us a message and let us help you to guide you in the right legal direction for yourself and for your family. In today's episode, we'll tread where even the courageous avoid in contemporary Nigeria. We'll be talking about legitimacy of children and their inheritance rights. So sit up, guys, and pay attention because we'll have a few surprises for you today. Under Nigerian law, the status of a child's birth is still formally recognized in the traditional categories of legitimate, quote and unquote, and illegitimate, even though the Constitution and modern statutes prohibit discrimination on that basis. In general terms, let us attempt a few definitions of the terms that are relevant to this discussion. First, illegitimate child. An illegitimate child is defined at common law as one born outside lawful wedlock. In Latin, nullius filius. Statutorily, the Legitimacy Act, which is still applicable in Nigeria, provides that a child born out of wedlock is illegitimate until legitimated by the subsequent marriage of the parents or by an acknowledged paternity. That is the father saying, yes, he or she is my child. In addition to this definition of legitimacy and illegitimacy, there is the presumption of legitimacy under the Evidence Act in Nigeria. Section 165 presumes every child born during a valid marriage or within 280 days after its dissolution to be the husband's legitimate child. By necessary implication, if you ask me, or inference, children born outside marriage fall outside this presumption and are therefore to be regarded as illegitimate. Note that this presumption is rebuttable by strong evidence of non-access or impotence or proof through DNA testing. By necessary inference or deduction, when paternity is rebutted, wouldn't such a child be termed as illegitimate? Now, the effect of marriage nullity under the Matrimonial Causes Act is another reason to think that our laws condone the categorization of children between legitimacy and illegitimacy, because it provides that a decree of nullity of a voidable marriage shall not render illegitimate a child of the parties born since or legitimated during the course of the marriage. Conversely, I think it's fair to reason that a child that is born when there is no valid marriage subsisting between the parties may be termed illegitimate under the Act. But there is succor. It's not all lost. There is constitutional provision against discrimination. Section 42, subsection 2 of our Constitution, as amended, prohibits disability or deprivation on the grounds of circumstances of the birth of a person. And the Supreme Court has held several times that this constitutional saving grace protects illegitimate children against unequal treatment in inheritance and administration of estates. But surely, it would seem to me to be a very elastic stretch of imagination to come to the conclusion that the Supreme Court's decision suggests that the court has thereby abolished the legal classification of illegitimacy itself. All it said was that such persons would be saved the harassment or embarrassment or deprivation that they may face by reason of being considered illegitimate. Now let us answer the burning question. Are children born by a man outside wedlock illegitimate? The answer, is yes, except where there is subsequent legitimation under the Legitimacy Act, or where there is a judicially proven acknowledgement. A child born outside a valid marriage is classified as illegitimate under Nigerian laws that I have just shown to you. But the modern trend, anchored on the Constitution and judicial interpretation, ensures that such children, once parentage is proven, cannot be discriminated against in inheritance or in the administration of the estates of their forebears, or denied other legal rights to which they may ordinarily be entitled as such. In practice, therefore, whilst the label illegitimate remains in our statutes and case law, its harsh disabilities can be and are increasingly mitigated or removed altogether by dynamism in customary practice and by judicial activism, which is rightly commendable. Under Nigerian law, the status of children born out of wedlock has been hazy. Clearly, children whose birth do not meet the requirements of Section 165 of the Evidence Act may be labeled as illegitimate. So also are children born outside the contemplation of Section 38, subsection 2 of the Matrimonial Causes Act. There are, however, saving graces, which, as I have just told you, are provided by Section 42, subsection 2 of the Nigerian Constitution, and a plethora of decided cases, judicially decided cases, which clothe such children with inheritance rights when the facts are favorable. But let me point to a clearer light at the end of the tunnel. The ever-standard pillar for children who may be otherwise labeled illegitimate is the Child Rights Act. Children born outside wedlock are not considered illegitimate in the strict sense, especially when it comes to inheritance and recognition. Here is a breakdown of how this issue is treated. We have done a lot of inferences, but it may be fair to argue that Nigerian statutes do not expressly disqualify children from inheritance merely because they were born out of wedlock. The wills law in many states, like Oyo and in Lagos State, recognize natural children, that is to say, children who were born outside marriage. They are recognized as dependents or persons entitled to challenge a will or benefit under intestacy. Such children have legal rights too, and they have legal rights to their father's estate, especially if paternity is already acknowledged or proven before the death of that father. Traditionally, paternity is crucial. If the father acknowledges the child or carries out certain customary practices like naming or accepting the mother into the household, the child is considered legitimate. Some ethnic customs may initially treat out of wedlock children differently, but court rulings increasingly override such customs where they are discriminatory or violate human rights. In spite of all of this, we can, and perhaps because of all of this, we can categorically assert that children born outside marriage, in a legal sense under Nigerian law, can inherit from their father's estate in spite of their categorization, especially where paternity is not in dispute. And this is more so because any custom or law denying them such right is considered unconstitutional. Though this may make some men happy, I should quickly say that our intention here is not to encourage proliferation of children outside marriage, but to ensure that children who have no say in how or by whom they are born do not suffer by reason of the circumstances of their birth, even when it might be the result of indiscretion. We'll try to provide backing for you for what we have told you this far by giving you in plain language detailed analysis of landmark Nigerian cases decided in our courts concerning legitimacy and inheritance rights of children born outside wedlock. Whilst we're at this, please do not forget to click the subscribe button if you find this valuable. First, I will tell you the story of the family of Chief Salubi, who died intestate in 1982. He was survived by his widow and 2 children born within the marriage, and yet 2 other children born outside his marriage, whom he had acknowledged and raised in his matrimonial home. Letters of administration were granted to his widow and his first son. The widow later declined to act, and the first son managed the estate alone. The eldest surviving child, Mrs. Benedicta Mwariako, sued, seeking equitable distribution of the estate amongst all beneficiaries. The issues that came up for determination included whether the estate should be distributed according to robo-customary law or the administration of estates law of Bendel State, I assume, and whether the children born out of wedlock were entitled to inherit from their father's estate. The matter went all the way to the Supreme Court, and there, the wise men held that the administration of estates law was applicable and not robo-customary law. And this was due to the fact that the deceased marriage was under the marriage ordinance, which we now call the Marriage Act. The court, invoking the relevant section, Section 42 of the Constitution, ruled that children born out of wedlock and children born within the marriage must share equally in a deceased parent's estate once paternity is established. This clearly shows us that even though a child may be termed illegitimate because he was born out of wedlock, once that child is acknowledged by the father, the child has equal rights of inheritance under most administration of estate laws, and indeed under most customs in Nigeria. In another matter that involved the family of Mbodu that was decided in 2015, a child that was born out of wedlock was excluded from the administration and inheritance of his deceased father's estate. The child was aggrieved and sought legal recognition and inclusion. The primary issue for consideration before the court was whether exclusion of a child born out of marriage from an estate is lawful. The matter went on up to the Court of Appeal, and the court said that such an exclusion is unconstitutional because a child born out of wedlock is a child. And upon acknowledgement by the father, that child is entitled to partake in the administration and inheritance of their father's estate. Therefore, excluding acknowledged children born out of wedlock from inheritance violates our Constitution. It's against natural justice, equity, and good conscience, and should not be allowed to stand. There's yet another good story that you should hear, which involved the estate of a Yoruba man who died intestate, leaving children from 2 different women. One set of children challenged the inheritance rights of the other children, arguing that they were born outside marriage and that as such, under customary law, Yoruba customary law that is, they had no rights of inheritance. The court was faced with the issue as to whether all children, including those born outside formal customary marriage, have equal rights. That is to say, children born by the side chick of a man who married under customary law only, should they have equal rights of inheritance under Yoruba customary law? Again, they dragged this matter for years up to the Supreme Court, and the Supreme Court ruled that the children of the deceased, regardless, all the children of the deceased, regardless of the status of their mothers, the marital status of their mothers, such children have equal rights to inherit from their father's estate. As at this, the Supreme Court emphasized that under Yoruba customary law, the status of a child is not determined by the marriage status of the parents. It is determined more by the fact that the child is acknowledged by the father to be his child. And so we can boldly say that this matter clarified that Yoruba customary law does not discriminate between children of different maternal backgrounds. It reinforced the rights of children in family succession and contrasted sharply with more rigid customs like that which applies in Igbo land, where oftentimes if a child is not said to be legitimate, the child is discriminated against and may struggle to find space within the family. These cases collectively affirm that under Nigerian law, particularly the Constitution of Nigeria, children born out of wedlock are entitled to equal rights of inheritance, provided that paternity is acknowledged. It is time to go, but I can't possibly do this without thanking you for spending a bit of your time with me on today's episode of Your Family Lawyer. If you enjoyed this episode, or even if you did not enjoy it, but you found it useful, please click the like button, make a comment, click the subscribe button, and share so that others may benefit like you have done. My name is Chuma Chinye, and I am Your Family Lawyer.